The Home Mortgage Law Show is a paid program and is intended as a resource guide for education, information, and entertainment purposes and is not intended to provide specific legal advice. The information that you hear should not be used as a substitute for competent legal advice from a professional attorney. Hiring of an attorney is an important decision which should not be based on advertising or the information that you hear today.
Good afternoon and welcome to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Attorneys Shay DuPont, joined today by attorney Michelle Hanash, our bankruptcy attorney. They're here with you like we are every Saturday afternoon from 2 until 4 o'clock on our flagship station, News Talk 610 100.3 WIOD and 970 WFLA. The number to call into the show, it's toll free, 866-610-NEWS. That's 866-610-6397. AT&T Wireless customers, star 610. It doesn't matter where you are. If you can hear the show, you can call in with your question, concern, or comment. And of course, follow us on Facebook and Twitter, the Home Mortgage Law Show on Facebook, and on Twitter, it's Morris DuPont, PA.
And good afternoon, everyone. I'm Shay DuPont, joined here today again by Michelle Hanash, a bankruptcy attorney. Yes, Michelle is the bankruptcy attorney here at Morris DuPont, and she also manages our debt department, I guess you'd say, debt settlement, credit restoration. Michelle, what's going on over in the bankruptcy department?
Well, we actually had this past Friday a view from the bench, which is where once a year the judges get together and discuss all these really important issues that are going on in the bankruptcy world. And of course, one of those topics that was covered, which we've covered not extensively, but I think it's a very important topic to cover, which is stripping second mortgages in Chapter 7.
That's the
McNeil decision,
Yeah.
exactly,
Mm-hmm.
which allowed now for second mortgages to be stripped from property. When normally we could only do this in a Chapter 13, now we're able to do this in a Chapter 7. And the odd thing about it is we don't know for how long we're going to be able to do this. You know, you might think something's the law. It's the law. Sure, now we can go ahead and do this. But actually, this decision, which allows for stripping second mortgages, and we should probably define what that means.
Exactly. What does it mean to strip a second mortgage?
So we look at the current market value of your property. And if you have a first mortgage on that property, if you have a mortgage on it, is your home underwater with regards to that first mortgage? And if it is, if you owe more just with your first mortgage than the property is worth, that means you're underwater with regards to the subsequent liens on the property. A second mortgage, a HELOC is included, other types of liens. And that means in the bankruptcy world, if they're completely unsecured with equity, we can completely strip them off. So not only through the bankruptcy is your personal liability extinguished, so is the lien when you've completed your bankruptcy and received your discharge.
Okay, so let's use a hypothetical.
Sure.
You've got mortgages on the property of $400,000.
Right.
The first mortgage is a $250,000 mortgage.
Yes.
The second mortgage, or HELOC, the home equity line of credit, that line of credit is $150,000.
Okay.
The value of the property is now $240,000. So that means that it's less than the value of the first mortgage on the property, which is $250,000. It's underwater on the first mortgage by $10,000.
Right.
And the second mortgage, we now know, is unsecured.
Right.
Can you strip the second mortgage, the HELOC, in that example in a Chapter 7?
In that example, yes, you can strip that HELOC from the property. Of course, I'm a bankruptcy attorney, so I always have to say, generally speaking,
Of course, the caveat.
$10,000 just to bring it up is pretty close
Sure.
to that mortgage balance. So with $10,000, there could be appraisers who could have a dispute there. But that aside,
everyone's agreed that
everyone's
it's worth,
agreed,
right, that it's worth $240. Okay, now in that same example, the value of the property is $250,001.
right, then you cannot strip. Even 1 penny and you can't strip.
Dang it.
Exactly.
That's really the battle of the appraisers at that point, right?
If it's that close, then it sure does become a battle of the appraisers, and you have to get them on the stand, and then ultimately the judge will decide who is a more credible appraiser.
Because you know what? I had this case this past week. I met with someone in the Tampa office,
Mhm.
and it was so close. It was like $9,000 difference. And I explained to them that, yes, it's unsecured and we can try through a loan modification to modify the first. But before we modify the first,
You might
let's
want to
get
consider
rid of the
bankruptcy.
second.
Right.
And you want to get rid of the second now because it is definitely looks like it's unsecured. As time goes on and the value of the property goes up, suddenly there might be equity in the second mortgage and you won't be able to strip it in a Chapter 7. And they had a bunch of credit card debt. They had some business debt. So I was like, now is the time to do it. So timing is very important because as values of property increase, if you get $1 over the value of the first mortgage, that is making the second mortgage secured by, like you said, a penny. You cannot strip the second. So timing becomes very important.
Timing for the value of the property. And like we said, because we don't know how long we have this opportunity to strip these mortgages.
Yeah.
Once the motion, which is already pending to have this judgment reviewed, is granted, then automatically, even before a decision has been made, we might have to stop stripping seconds in Chapter 7s just when it's been granted that this judgment will be reviewed.
Now, is this true right now that you can strip second mortgages, HELOCs in a Chapter 7 bankruptcy? Is that true across the state? We know it's been true for some amount of time over on the Southwest, in the Southwest. For our Tampa clients, St. Petersburg, all down the coast there, and recently, the last 6 months in Miami-Dade County. But what about in other counties?
Yes, so this is an 11th Circuit opinion, meaning all of Florida, parts of Georgia, everywhere in the 11th Circuit, this is now binding.
Federal.
Exactly. That's the federal jurisdiction that the bankruptcy courts are under here.
Mm.
So before, I think it was August, this opinion was actually published. Before that, it was just persuasive. So that's why you would find in Tampa we can strip, in Miami they're not, but this judge in Miami said okay, and that one in Broward said no. You had a lot of differing outcomes depending what judge you were in front of and where you were. Now this opinion has been published, so it's actually binding on the judges. But like we said, we don't know for how long it's going to be binding.
Okay, so let's get back to it. So it's kind of, I think it's interesting to explain to people kind of, different jobs, different ways. We're lawyers. What are some of the things that we do as a lawyer? So one of the things that happens for a bankruptcy attorney, and this happens also for other attorneys, is the judges that oversee cases that bankruptcy attorneys are involved in, they once a year, twice a year, do a view from the bench, which is they allow all the bankruptcy attorneys to come in. Everyone's invited. And isn't it over a lunch?
It's actually from 8 o'clock in the morning till about 12:30 in the afternoon.
Oy.
So it gets out right before lunch, but they do provide danishes and coffee. So that was very
So
nice.
how many bankruptcy attorneys show up for this?
I think I noticed this year it seemed a bit down in attendance from the previous year, but several hundred attorneys come.
Wow. And you can ask questions of the judges, or they just espouse, their wisdom upon you?
Mostly they're espousing their wisdom upon you. Sometimes when I've seen very hot topics that were very controversial, especially last year, maybe there were more questions from the audience. But this year, it was limited mainly to them just gracing us with their wisdom, which is always very, very nice.
Absolutely. Well, when we come back, I want to hear more about what's happening in the bankruptcy department. Maybe you'll share some of your success stories for the week with us. Don't forget the law firm of Morris DuPont. You can give us a call at 800-974-2712.
That's right, 1-800-974-2712. Toll free to book your free consultation at the law firm of Morris DuPont, PA. If you can hear the show, there is an office near you. Shay will tell you all about that right after the break here on the Home Mortgage Law Show. You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. We have attorneys Shay DuPont and Michelle Hanash, our bankruptcy attorney, in the house until 4 o'clock. If you've got a question or concern, if you're have some doubts. That's why the experts are here. They're here to give you clarity, to give you options, to give you choices, to show you that light at the end of that dark foreclosure or bankruptcy tunnel. The number is the same wherever you are to call and talk to the experts right here on the show. It's 866-610-NEWS, 866-610-6397. AT&T Wireless customers, star 610.
And we're back talking with Michelle Hanash, a bankruptcy attorney at the law firm of Morris DuPont. And I want to remind everyone, you are welcome to call the show and ask your questions to Michelle regarding bankruptcy, debt settlement, credit restoration. Remember, don't wait until you believe that you're now ready to file bankruptcy. Come and get a free consultation with our bankruptcy attorney so that the timing of your bankruptcy and preparing your finances for that bankruptcy can be done prior to you believing that, well, now I'm ready. Now I've done what I need to get done. Now I should file bankruptcy. Why would you be making those decisions on your own? And how would you know what's the proper time to file bankruptcy? You wouldn't unless you met with a bankruptcy attorney prior to the time that you believe you should be filing bankruptcy so that they can help you prepare for when the timing is correct and how to take advantage of what bankruptcy can offer to you to the fullest. Because, Michelle, I know I've certainly seen people come in and tell me that they did this, that, and the other, and because they're getting ready for bankruptcy, and I was like shaking my head thinking, well, now why would you do that in preparation for bankruptcy when bankruptcy could have solved that or can't solve it? Or, gee, just, even a month ago, if you had done something a little differently, you could have taken advantage of the bankruptcy laws.
Not to mention, you don't want someone to just assume that they will be able to qualify for a bankruptcy or that bankruptcy is the right option for them. Then it comes time to when they think they should be filing and they find out, oops, no, I don't qualify. So I always tell clients, even when they don't come in to meet with me, let's say they've come in for a low mod consultation with you and I get pulled into the conversation just to talk a little about bankruptcy, I always ask them to fill out my questionnaire. I always explain to them that we want to know, I understand you have this plan in your head that you're going to file for bankruptcy in 2 months or whenever it is, but let's make sure that that's actually an option for you and the best option.
Yeah, that's very important because qualifying for bankruptcy, the laws changed a couple of years ago and the qualifiers for bankruptcy have changed. So you might assume, anybody can file for bankruptcy. That's not true.
Right.
And it's a lot more restricted than you would think. But don't make assumptions. Call the law firm of Morris DuPont, schedule your appointment, and allow Michelle to take a look at your finances and understand whether or not you can qualify, and if you can, when would be the right time to file and what chapter you should be filing.
Right.
So remember, we have offices in St. Petersburg, Tampa, Dadeland, Doral, Fort Lauderdale, Aventura, Plantation, Boca Raton, and West Palm Beach. You can schedule your free consultation by calling the law firm, and that number is 800-974-2712. I'll say it again. It's 800-974-2712 to schedule your free appointment to meet with one of the attorneys at Morris DuPont and see whether or not you can qualify for bankruptcy, a loan modification, short sale if you need foreclosure defense, all consumer law relating to issues that might be affecting you and your family. Morris DuPont handles it. And if you're driving, don't worry about the phone call. Remember homemortgagelaw.com. That's the address for the web page so that you can go and look at the Morris DuPont website, pull the number off of there. You can actually request an appointment through the internet, and that again is homemortgagelaw.com. So Michelle, let's go back. You were talking about a view from the bench when all the bankruptcy attorneys, meet with the bankruptcy. Well, the bankruptcy judges meet with the bankruptcy attorneys and kind of they talk about their impressions, their view from the bench that's been going on.
Well, they have a lot of pointers that would probably be boring to most of the listeners about, practical help on filing motions and how long they should be and when you should have a cover page and when you shouldn't. So we won't go into those boring details for the listeners.
Thank you.
But one topic I was actually surprised that we spent so much time on was student loans. And it's always been my understanding and the general consensus that you cannot discharge student loans in a bankruptcy unless, unfortunately, you're practically in a coma. They are just so hard to discharge in a bankruptcy. And it seems that there's a trend now, this momentum towards revisiting these rules we have as to how difficult it is to discharge student loan debt. And there's a very high standard. It's an undue hardship, not just a regular hardship, but this undue hardship. And if there's no prospect for repayment anytime in the future, and just very few people qualify for discharge under these very harsh standards. But it's interesting to think that at the time these standards were created, student loan debt had a statute of limitations of 5 years. So this was an early way to discharge your student loan debt. So you had to meet these very high standards. Now, student loan debt is practically, you're stuck with it for life. There's no statute of limitations. So this very harsh view of discharging this debt in comparison with now there's no statute of limitations. This is a debt that can be collected forever, that can hang over someone's head forever. It just doesn't seem equitable anymore.
So did they give an example of what an undue hardship could possibly be?
Well, the case law that I've seen, actually they give a very funny example, and maybe I should lead with this. It was a case called Wolf, where a person representing himself as a pro se debtor who had gone to law school but had to leave 3 weeks short of graduation. So he was someone who was versed in the law, but was kicked out for being a difficult person, for getting into a fight with, I believe it was a speaker who had come to campus. And his whole platform of why he should be discharged from his student loan debt was because he was such a difficult person that no one would ever hire him. He couldn't, or no one would ever keep him employed. They would hire him and then he would get fired. And so he brought in all these former employers to testify who said, yes, it's true, he's difficult. We cannot, we had to fire him, one employer after another. He brought in a psychologist who came and testified and said, it's true, he's so difficult. This is not a situation that he's going to be cured of. It's for life. And I believe in that case, actually, they found that he would not be able to repay this debt. He was making a very meager, let's say, amount of income and living very modestly. And the judge in the case agreed that he would not be able to repay. And it was based on a personality defect, let's say.
Wow.
So that was a
if that argument flies, I'm sorry. I think that there's a lot of people that we could help to get their student loans discharged as in the category of undue hardship.
You would think so. You know, another judge gave a story that actually you could tell she was a little emotionally torn up about the decision she felt she had to make, where a couple, both, I believe maybe both were teachers or one was a teacher, had a master's. They had a very large amount of student debt. They had a child, and then they actually had a child that was disabled. And that was draining their finances. And for years, they had made payments in good faith and filed for bankruptcy.
Please tell me they were granted.
They weren't.
They weren't?
No, the judge said that when she reviewed the finances, that actually on the evidence provided, and this is important to note, they were pro se debtors, and perhaps with the help of an attorney, they could have actually presented a better case. But based on the evidence, and she really harped on that, the evidence before her, she had no choice.
Oh, okay.
But to say that in their budget, they actually had some potential to pay back the loan.
Because I've gotten student loan discharged for someone who started receiving disability.
Right.
Because they were permanently disabled, I was able to get the student loans completely discharged because it was obvious that they were never going to have income.
And that's the classic clear-cut
And that was
case.
outside of bankruptcy court.
Right. And, in the first case, it is important to note that this gentleman was already 55 years old and had gone for many, many years where he was unable to pretty much make a dent in these payments. Okay. And, there is a little different.
Well, lots of different issues coming up. Bankruptcy, loan modifications, short sales, foreclosure defense. Don't forget, Morris DuPont does it all.
1-800-974-2712. I see Jose has a good question. We'll answer that right after the break. 1-800-974-2712. That's the number for your free consultation at the law firm of Morris DuPont. Much more of the Home Mortgage Law Show right after this. And You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont, PA. Attorneys Shay DuPont and Michelle Hanash here for you. The number is the same wherever you are. If you're in your car, you should already have it programmed to your cell phone. Give it to a friend or a neighbor. 866-610-NEWS. That's 866-610-6397. AT&T Wireless Customer star 610.
And we have Jose on the line. Let's go to the phones.
Hi, Jose.
Hi, Jose. What can we do for you today?
Hi.
Hi.
Thank you for taking my call. How
Well,
are
thanks.
you?
Good. Thanks for listening to the show. We appreciate it.
Oh, it's a great show. Yeah, let me tell you, I have a modification for 3 years. It's temporary, and it's about to complete, right? With my investors say they don't participate in Obama plan. They don't participate in anything. No, they don't take government money or anything like that. So the first time when I tried to do it, I did it myself. The services never helped me very much. So I was disqualified. The first time, that was 4 years ago. They told me I won't qualify because of the debt ratio. So after that, contact the investor myself directly. I request the paperwork for the guideline for modification. And they told me that was internal paperwork. I cannot have an access. So in the letter said you don't qualify because of your debt ratio. So finally I made them explain to me. It was very difficult. So I adjust the number again and review it and send it, and I did qualify. That was 3 or 4 years ago. Now I'm in the same situation because it was temporary. I asked them in the email, you still have the same guideline as 4 years ago? And they said, well, the only thing we can tell you is you got to be over 31. Your debt ratio cannot be over 31 or under 31, something like that. They don't give me so many information so I can arrange my numbers. I don't say put it something that is not true. Just be sure about what I'm sending. So my question is, I'm still pending with the decision. It's going to be 3 months waiting for the second temporary modification. They don't want to do it anything permanent. Do I have the right to request the guideline for modification from the investor? And they can send me that information in paperwork? That what you guys do? Or that what they say that's internal paperwork?
Jose, these are all really, really good questions. You have done a really fabulous job on your own of getting a lot of information out of the servicer and then going behind the servicer and actually talking to the underwriter or the owner of your note. So kudos to you for all that you've been able to accomplish thus far.
Oh, I see. So, but who made the decision? Because they do the paperwork, the services look like they do some kind of work.
Yes.
But then they have to send it to the investor. So like an investor is reviewing everything. Who's supposed to do the job? The services or the investor?
You have a lot of questions. I'm going to try and get to them all. So who is your servicer? Who's servicing your note on behalf of the investor?
Oh, it's Space Coast Credit Union.
What is it?
Space
Coast Credit Union. Space Coast Credit Union. Okay. So credit unions, typically, historically, very difficult to work with because credit unions do not participate in the Making Home Affordable program. So they don't have to comply with, like you said, the Obama program, HAMP, HARP, HAFA, all of those. So there's an individual investor, maybe it's a trust, whatever, that is the actual...
Federal Home Bank of Atlanta.
Okay.
Federal Home Bank of Atlanta.
Okay, so there's the Federal Home Bank of Atlanta, and that is the actual investor that owns the note. So if you can visualize, folks out there, you've got this mortgage servicing company, and in Jose's case, it's Space Coast Federal Credit Union. In your case, it might be Bank of America, Chase, Wells Fargo, Citi, but they're just mortgage servicing companies. They service the mortgage on behalf of the investor that owns it, and they are the entity that you have contact with. They send you your mortgage statements. They do the escrow. They send you warnings about foreclosure, but they don't own your note. Everyone thinks that the mortgage servicing company, Ocwen, Greentree, that they own your note. They don't. There's an investor behind them that does. It might be Fannie Mae, it might be Freddie Mac. In Jose's case, it's Federal Housing Bank of Atlanta. So,
Yes.
Jose, your question, what is the servicer's job in a loan modification and what is the investor's job? Well, the investor makes the final decision on whether or not you're going to qualify for a loan modification, and it's the investor's programs that you are qualifying for. But the servicer is doing the initial quality control
Oh, I see.
as to the contents of the application, and they can screen it for a denial because if it doesn't hit certain of the investor's guidelines to even be considered for a loan mod, then the servicer can deny it. If you don't have the right DTI, the debt to income ratio,
Right.
then the servicer can disqualify you because they already know you're not going to qualify, so they don't need to send it to the investor, the underwriter, for a decision because the investor and the underwriter has provided the servicer with the guidelines that say, don't bother sending us any if they don't already meet this criteria. So
Right.
when you talked about the 31%, what that is are you today currently paying more or less for
Right.
your monthly housing expense
Right.
of 31% of your gross monthly income? So if your gross monthly income is $5,000 a month, then your 31% figure is $1,550, right? Yes, that's right.
Right.
So,
What about requesting the guideline that the service has from the investor? Can I request it myself?
no, you cannot get that information that is proprietary. If it is not a government program that is a published program, then it is the investor's proprietary program, and they do not have to share that with you.
The
So,
attorney also can.
pardon me?
An attorney also cannot get it.
Cannot get it. I cannot get it because it involves what's called the NPV test, the net present value test, and
Right.
each entity has a different NPV test that they use,
So
and
how
they
do
don't
you
have to share
know-
that with you.
How do you know they discriminate against some people or they don't? How you control if they really follow certain guidelines? This is totally internal, right?
That's
Nothing you
right.
can do.
That's
Nothing
right.
you can do.
Well, there are some things like I can send out what's called a QWR, a qualified written request. And if I put the correct statutory language in there, I can get a lot of that information, but I can't get all of it. There, like the
Right.
NPV test, I cannot get that. But I
No, you
can
can get
see
that.
what income they considered you to have and the 31% figure. And a lot of the calculations can be revealed to me, but not all of them. So I do have some ways to appeal that decision. But again, they don't want to provide it all to you. And you know why? Because you can manipulate then your modification application to make sure that you hit the numbers correctly to qualify. So they don't want you to be able to do that. They want you to just present whatever your income is today. Don't manipulate it. You either qualify or you don't.
Right. Yeah, well, what I'm saying, I think I'm going to get it the second time, but at the beginning I was working a little blind, right? Now I know, because I told him I have a rental income, which is true. I have an efficiency in my house. They say, okay, and I proved them with a cash deposit every month.
The
for
lease,
years,
yes.
and I prove it. But then they say they send in an email from the investor where they say if it's not in the taxes, they cannot accept it. But I sent a letter. They said, I don't have to report it in the taxes. It's like if someone is helping you with your mortgage, and you don't have to put it as an income.
Right. So
But-
there are ways of disputing it. When a lender comes
Right.
back and says something, you can do what's called LOEs, letters of explanation, a letter of explanation, and you can actually appeal a decision by
Right.
the investor. But you've got to know that you're in the right, and you seem to have done a good job, Jose, of finding out that you're in the right. I've only got a couple of seconds before we've got to go to break. I want to thank you for calling the show. Thank you.
Thank you. I will call your office.
Well,
all right.
great. We'll
I
try and
really
help you.
appreciate it.
Appreciate it.
All right.
Don't forget, we do have offices in Tampa, St. Petersburg, Dadeland, Doral, Aventura, Fort Lauderdale, Plantation, Boca Raton, West Palm Beach. Schedule your free consultation. I'll sit down with you. I'll crunch some numbers, see if I think you can qualify for that loan modification, explain DTI to you, explain what a monthly housing expense is, explain these government programs where you could possibly get a loan modification and see your mortgage payment go down to a 2% interest rate.
1-800-974-2712. That's the number to get a hold of Shay and everybody else at the law firm of Morris DuPont, PA. 1-800-974-2712. 1-800-974-2712. Much more of the Home Mortgage Law Show right after this. You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Our phone lines are open. You can call and talk to the experts, attorneys Shay DuPont and Michelle Hanash, our bankruptcy attorney. 866-610-NEWS, 866-610-6397. AT&T Wireless customer star 610.
And let's hit the news now, because unfortunately we've got some bad news to share. These mortgage rescue scams are still going on. We've got in Broward County 2 men that were accused of defrauding hundreds of homeowners and pocketing a collective $3.5 million. Why? By promising them mortgage loan relief that never came. We're talking about Brian Berry, 41, of Oakland Park, and Blair Wright, 55, who ran Outreach Housing. So if anyone out there went and gave money to Outreach Housing to help get a loan modification, help somehow lowering the mortgage payment, unfortunately, you were probably the victim of a scam and might need further help. But good to know that Mr. Berry is currently in Broward County charged with racketeering and conspiracy to commit racketeering, being held on a $75,000 bond. So I hope this is getting close to the end of these kinds of mortgage rescue scams. I mean, when we started the firm back in 2009, this was probably
rampant.
a monthly occurrence that we
Right.
would see people do this. You know, a lot of times it was former mortgage brokers that were now out of work and they got roped into doing this, and then it turns out they were overwhelmed, or people that actually went out there and just tried to defraud people, which is just boggles my mind. But there's still, you know, some of them left. So you have to be very careful that remember, you do not have to pay an upfront fee for a loan modification if you're doing it through a company. You would pay if they are successful. Only a law firm has the right to charge an upfront fee.
There's so many benefits to the working with an attorney, obviously, than one of these kind of companies that aren't allowed to charge an upfront fee. I mean, you see this, I think especially with these mortgage loan modification fraud schemes, you see these with these random corporations, non-attorneys, people we don't know what their backgrounds are. Maybe they were mortgage brokers. I just feel like it's very suspect when you're going to a non-attorney to help you with a loan modification.
Absolutely. And then let's talk about the infamous David Stern.
On the other side
is the attorneys that aren't so good.
Right.
Yeah, we got David Stern, who, if you all remember David Stern, he was the king of the foreclosure mills up in Broward County. He ran the law firm of David J. Stern, and it really basically crashed and burned back in,
2011.
Well, it closed in March
Right.
of 2011, but actually it really was in the middle of the GMAC robo-signing scandal that occurred in October of 2010, and that's when it was exposed that the law firm of David Stern was doing a lot of robo-signing, and all of these big companies, Fannie Mae, Freddie Mac, Citi, Bank of America, they all fired him because he was representing them as their counsel when they were filing foreclosure actions against homeowners and presenting these falsified documents to the courts. So they all fired David Stern, so that firm kind of crashed and burned. And here it is today in 2013 that his trial has been completed, and the Supreme Court has received a recommendation that he be permanently disbarred from the practice of law. So
You think? I mean, it's that. Did we really need this 2+ year investigation?
Yeah. To be
I
fair, we
guess so.
probably do.
Everyone
You're
deserves-
taking someone's ability to earn a living away from them. So yeah, I want, if it
Of
happened to me, God
course.
forbid, there never would be a reason. But yeah, I would want there to be a trial, and I would be able to present evidence. But yeah, the referee's recommendation is that he be permanently disbarred from the practice of law. So I can't say that I would disagree with that decision. And then we go to, of course, Florida's hardest hit fund. We're all familiar with the hardest hit fund and its latest hardest hit principal reduction program. Well, it seems like it's being run just as well as Obamacare these days, in that there's a lot of complaints about the actual program that you have to apply through. There's a website that you would go to. If you remember last month, we were talking about the deadline happened to apply for the newest amount of money, the $350 million. It was going to be available to 25,000 applicants that applied by the deadline last month. Well, those applicants and those applications are maybe in a state of limbo because the website and the processing of those applications isn't going quite as smoothly as we would like to see it.
Are you surprised?
Yeah, I am, because I thought that because we've had the hardest hit fund going for 3.5 years now, that they would expect to receive these 25,000 applications within a matter of days.
Right.
And they have previously processed a certain number of applications. So I really was kind of surprised.
They should have been prepared for that, especially when you think that 100,000 borrowers in Southwest Florida, 1/3 of the region's homeowners are still considered deeply underwater. You would expect 25,000 perhaps
in a matter of days to apply
right.
for this money. But even with the number of applications, when you look now a little beyond the surface of these reports, you can see that even if it's not maybe underfunded or mismanaged, it really isn't helping the number of homeowners that we would certainly like to see. Let's remember the hardest hit principal reduction program is to help those homeowners who have negative equity on their property and who owe 25% more in mortgage debt than the current value of their primary residence, as long as that outstanding principal is below $350,000. And think about it, that, like you said, over 109,000 people in Southwest Florida alone fit into that category.
Right.
So I would love to see a lot of people be able to qualify for this money to help them get that loan to value back down to something that could actually be reasonable, so that they would stay in the property and keep this being a performing loan. And then last but not least in the storyboard, we've got O.J. Simpson's house goes into foreclosure. Well, I'm not going to be shedding a tear for this, but it is kind of interesting that it actually sold at a foreclosure sale for $655,000, and he actually owed Chase Bank $892,000. So there were banks out there that were actually willing to lend this man a good amount of money.
A lot of money.
Yes, so that actually it wasn't so much I was surprised by the foreclosure. I was surprised by the banks that thought, yeah, this guy seems like a good credit risk. Sure, we'll lend him some money. I know we've got a phone call. Let's try and get it before we've got a break.
Kurt, welcome to the show.
Hi, Kurt. How are you?
Hi, Shay. I'm well, thank you.
Great.
Listen, I have a second mortgage through City Financial, which I have not made a payment on since June of 2012. Now, I initially owed $120,000 on the second mortgage, and I've been offered through City Financial, after ignoring them for the last 14 months, they're willing to settle for $36,000. They initially offered to settle for $73,000. I wrote back and told them, no, thank you very much. So then they came back and yesterday offered to settle for $36,000.
Mm-hmm.
Now, I'm coming up to the deadline of this year, to where I think next year they might eliminate that tax break. What do you think is that a reasonable settlement offer for them? Should I accept that, or should I just keep haggling with them?
Well, the first question I have, Kurt, is what is the first mortgage on the property? What's the principal balance on that?
160.
160?
Yeah.
And what's the current market value of the property?
Oh, I would say it's close to 300.
It's close to 300. So you've got a first mortgage of 160,000, and you have a second mortgage of 120,000. You haven't paid on the second mortgage in over a year, yet it's a 100% secured note, and they're offering to settle it for $36,000.
Correct.
I'd be writing that check right now.
Yeah.
Absolutely.
That's a 30% settlement. Considering it's secured, I think that's fabulous.
Citi could go and foreclose on your property and receive dollar for dollar on the sale of that property.
I hope City's not listening.
Well, no, here's the ironic thing. 18 months ago, the house was underwater, but because they've come up so much in value in the last 18 months, that it's now,
That's an amazing recovery. If it was underwater, meaning the value of the property was worth less than $160,000 a year ago, and today it's worth $300,000. Yeah, I would take I would definitely settle for the 36. We've got to run. If you want to follow up on that, stay with us.
You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont. 800-974-2712. That is the toll-free number to call and book your free consultation. 1-800-974-2712. Much more of the Home Mortgage Law Show right after this.